A very good afternoon to one and all present here. Ladies and gentlemen, my dear friends, esteemed members of the legal fraternity, our honorable chief guest for today's evening. I am very ecstatic to be a part of this wonderful and magnificent session organized by BW Legal India. And the theme for today's panel discussion is exploring the role of mediation arbitration in resolving commercial disputes, best practices and challenges. This is a very pertinent topic in today's time where we are moving from a culture of conventional to corporate. So today we have with us this wonderful panel who are going to shed some light on this panel discussion. First of all, in the line of power speakers, we have Mr. Tariq Khan. Mr. Tariq Khan is an office bearer at the International Arbitration and Mediation Center, Hyderabad, in the capacity of a registrar. Sir was formerly engaged with Advani & Co. as a partner, which is a very prestigious arbitration firm in India. Sir is an avid academician and he has authored numerous books on the arbitration law. Apart from that, Sir is a giver to the society and a mentor for all. Thank you so much, sir, for being on the panel today. Next in line, we have with us Madam Debosmita Nandy. Madam Nandy has graduated from National University of Juridical Sciences, Kolkata as a gold medalist. Ma'am is currently heading the position of Chief Legal Officer at Cinepolis, India. Also, ma'am was employed with ITC India for a very long time in her career as Senior Legal Manager. Ma'am is also a blogger by passion and she has her own blog by the name of 5 Think Checklist. Madam, thank you so much for being here on the panel with us today and we are delighted to have you. Next in line of power speakers, we have Mr. Rajiv Choubey. Mr. Rajiv Choubey is one of the premier persons in the manufacturing and IT industry as a GC. Sir is there as a general legal counsel of Dalmia Bharat Cement. Sir was formerly appointed with ACC India. Sir has a vast experience in manufacturing and IT industry as he's rendered services in HCL Infosystems as well. Thank you so much, sir, for being here on the panel today. We're delighted to have you here. Next in line of power speakers, we have Mrs. Roop Loomba. Madam Roop Loomba has a vast experience of 20 years in the industry. Ma'am not only has an experience in the Indian subcontinent, but also of maneuvering legal operations in the South Asian countries. Ma'am is a GC with Akzo Nobel India, and also formerly she was employed with Rolls-Royce India as a GC. Ma'am has also held prestigious positions in companies like Philips and Whirlpool. Thank you so much, ma'am, with gracing the event with your beaming presence. Next in line of power speakers, we have Mr. Rajiv Malik. Rajiv Malik is a shining star of the FMCG industry. Sir is currently employed at LG Electronics as a general counsel. Sir is a giver to the society and we are really glad to have him in this fraternity. Thank you so much, sir, for being a part of this panel today and gracing the event. Now, I am a standing counsel and I would request everybody to be standing on the podium and ask you certain questions. I'm more comfortable here. If everybody's consent to that, I may proceed with the questions. Thank you so much. So my first question is to Mr. Khan. Sir, my question to you is that since we all know that you're at the epicenter of institutional arbitration in India, so how do you propose launching and propagating institutional arbitration in tier 2 and tier 3 cities? I am so sorry to call them tier 2 and tier 3 cities. There's no concept as tier 2 and tier 3 that I know. But still, what is your take on that? How do you propose to propagate this culture of arbitration in these cities, primarily in the purview of the fact that these are commercial hubs? Let us take example of Bhopal, Indore, Bhubaneswar or Jaipur for that matter. Open the floor to you.
Thank you very much, Shvetanshu. So now that I'm in Hyderabad, I was in Delhi all my life as a partner of a firm. So I'll talk about tier 1 cities first. It's very unfortunate that the focus is only on Delhi and Bombay when we talk about dispute resolution, arbitration or mediation. It's very rare that you will see, even the conferences which are being organized and, people talking about it, awareness programs. You'll not see many of them happening in Bangalore, Chennai, places like Ludhiana, Kanpur, which have a lot of business. There's not much discussion. Nagpur, for instance. So at least as a registrar of a center, we have done events in all these cities. And we believe that when you talk about making India a hub of arbitration, you cannot just talk about Delhi and Bombay. India is much larger. And especially when people compare India to Singapore, London. We did a roadshow recently, and that's exactly what I said. You can compare a Singapore with Hyderabad, you can compare a Singapore with Delhi, but just taking India as a general name, that India is the seat of arbitration, I think that's not the correct approach. Now, coming to how to build, an institution or a culture of arbitration or mediation, I think there is a need for an effective dispute resolution ecosystem, which is robust. For that, first thing that you need is a robust law, which I think is pretty much present in India, especially after 23rd October 2015, so far as arbitration is concerned. Much has changed. There's been a lot of development. I think we have come a long way. We have done great in the past 7-8 years. Second is you need a good judiciary that is supportive. Same thing happened in Singapore. The credit goes to the Singapore Supreme Court and the government, which has been fully involved. They enforced agreements, they enforced awards, they didn't interfere. So that's the kind of judiciary you need. More importantly, you need no reluctance to learning on part of judiciary as well as the bar, because you need to train your local bar. Unless the support from the bar comes, I don't think any city that aspires to become a hub of arbitration can really do well. A lot of institutions worldwide came and they just shut down. The reason is they gave too much importance to infrastructure, which in my view is the last. So I think, when you do capacity building, you do these awareness programs, and when you think of these cities, which are, in my view, not tier 2 or tier 3, I would call them emerging hub of business or emerging hub of arbitrations. So I think that's what the approach should be, in my view.
Thank you so much, sir, for a wonderful take on this question. I'm so sorry to modify this question. My second question to you would be that how do you intend to create that awareness for propagating this culture of institutional arbitration?
Okay, so I'll just first tell you what Justice D.A. Desai said on 29 September 1981 to give you an idea how far we have come. So there was a discussion in the case of Guru Nanak Foundation versus Ratan Singh. I'll just quote what he said. He said that interminable, time-consuming, and expensive court procedures impelled jurists to explore an alternative to the court system, and that led them to Arbitration Act of 1940. But the way in which the scheme of the act has been implemented, and without any exception, every award is challenged in court, has made lawyers laugh and legal philosophers weep. So that is what Arbitration Act 1940 looked like. So if you compare that with the present scenario, we've actually come a long way. Nobody really talks about the positive things. In fact, I was debating in London last week, and as usual, India was being criticized. And it has become a trend to criticize India in international conferences. And that's why people have actually started thinking there's something wrong with Indian arbitration ecosystem. And I do not agree with that. I think we are doing exceptionally well. If you compare where we have started, the only thing is we need more support, and we need to involve the GCs, the industries, the corporate council. Lawyers meeting lawyers does not make sense. You need to have GCs and corporate council as arbitrators and mediators. Unless that will happen, because they understand business better than any lawyer or a retired judge would understand, in my view. And these are personal views, of course. So I feel that arbitration and mediation should not be seen as a domain of retired judges or lawyers. You need to involve business if you really want it to grow and flourish. That's my take.
Thank you so much, sir, for a wonderful insight on this question. My next question is to Madam Nandy. Ma'am, my question to you is that you have a blog by the name of 5-Thing Checklist. So my question is that, in that sense, what is the 5-Thing Checklist to make a contract in your industry more mediation and arbitration friendly? Because in today's regime, we're fastly moving towards a commercial era. So how do you propose to make a contract more mediation and arbitration friendly? What is your take on this?
Thank you, Shvetanshu. To be honest, the contracts that I work on in my present company are already geared towards arbitration. We generally always go for an arbitration clause in all our contracts. What I personally do, and this is absolutely a personal opinion from my experience, is that I do not have a mediation clause in my contracts. What I have experienced is that usually when there's a clause which says that if there's a dispute, you raise it for mediation for 30 days and thereafter you go for arbitration, that usually is a waste of time. When the dispute happens, the business are anyway already talking, discussing, and trying to reach a settlement. So, whenever there is a clause like that in any other contracts I receive, I usually remove that and I keep only an arbitration clause. However, I know the session is on arbitration, and we do have only arbitration, only dispute resolution clauses. What I am experiencing, and which you can others can agree or disagree, is that arbitration is not suitable as a dispute resolution mechanism for all kinds of contracts, especially contracts which are short term, say a year or two, or are simple ones. The disputes which arise out of them are not very high value. Having arbitration for those contracts have really increased the legal cost for me, because any dispute I then have to resort to arbitration, which is sometimes turn out to be more expensive. So that's why these days I definitely look at a contract and see whether I should have an arbitration, and if an arbitration, then I am exploring new mechanisms like an ODR or such, so that I can reduce the cost. Because at the end of the day, the arbitration and litigation, whatever cost you say, they are very, very high. So, and of course, when it comes to the clause, we make sure, and every seasoned in-house lawyer knows that the best way is to nip the bud, any dispute at the bud. So at the contract drafting or negotiating stage, we make sure that the language is very clear, the seat, the venue, whatever mentioned, the court, all of that is in line with the latest jurisprudence, and there is no because there has been an experience where we have lost valuable time trying to institute say section 9 application in a court which was not supposed to be, and then after a long round of litigation the court decided it's not the right forum. So those sort of learnings we take and we avoid that so that in future everybody's clear as to the jurisdiction where one has to run to in case of an interim relief.
Thank you so much, ma'am. Ma'am, as Justice Sikri just quoted a few minutes before that, mediation is the savior of the legal system of the country. So my question to you is that, don't you think that mediation is an appropriate method of nipping the bud at the bottom itself, rather than going for the rigors of arbitration and other mechanisms of dispute resolution?
So of course I agree with that. Usually, I believe the mediation that has been talked about is the institutional mediation, and not the mediation which usually happens within the counterparties. Of course, that's a very important point. Every commercial dispute has to mandatorily go for a pre-litigation mediation now. My experience in that, when I was in my previous organization, I worked in a number of commercial suit and those sort of litigation. The mediation usually would never ever come to a fruitful ending. It would fail. However, what I have realized is that in some aspects, the mediation really, really helps. For example, in a criminal case, whenever there's a criminal case, sometimes it is a trend these days that a civil dispute is given the color of a criminal nature and it's filed, and it's a sort of an arm twisting and a tactic that is sometimes taken. In that case, whenever the party goes to the High Court under the quashing petition, the High Courts have resorted it to mediation, and that has really helped to resolve the issue. Because whenever there's a criminal case, there's a lot of ego in the place, and the parties are not in a mood to really settle outside. But under the court order in the mediation center, this has the the potential to work out for both parties.
Thank you so much, ma'am. Thank you so much. My next question is to Rajiv Choubey, sir. Sir, as we all know that, as ma'am has already said, that mediation is primarily more helpful in the criminal dispute resolution system, probably. But what is your say on the fact that how is mediation more successful in commercial disputes? And if not, then what is the roadmap to it? How can we improve it?
Yeah, thanks, Shvetanshu. See, I think we as in-house counsel or general counsel, we need to first understand that the organization where we are working is into some business. So I work for a company which is into cement, sugar and refractory. So our main business is to manufacture cement and sell cement and contribute to the revenue, employment generation and the larger objective of which a corporate functions. So we are not in the business of fighting litigation or disputes. I think we already have huge pendency. So if we are able to resolve any case through an ADR mechanism and more preferably mediation, it actually reduces the burden. And in fact, we all talk about arbitration and mediation, and sometimes maybe without understanding that what really mediation is. And I would like to thank my co-panelist Tariq for bringing me to Hyderabad, and now I can say that I am a trained mediator by Singapore Mediation Center, SIMC. And that actually gave me a completely different perspective about mediation. In the past, I have seen mediation failing. And the reason it failed is that if both the parties sit together and then they try and resolve the dispute will never get resolved. You need a professional mediator who is trained, he or she is trained to handle mediation, because the best part about the mediation is when compared to a court degree or arbitration is where the judgment is or the award is given by an arbitral tribunal or a judge. In mediation, the best part is that the judgment or the decision comes from the parties. So generally what happens in a dispute is party take position. So suppose I have a EPC contract, I feel the contractor has delayed, and since because of delay there are certain claims, I am entitled to certain damages. Whereas the contractor says that no, I am not entitled to pay you damages, or you have wrongly, deducted my liquidated damages because you gave me the site where there was a delay. There was a delay in terms of releasing the payment, or my labor entry was delayed because of procedure of the company. There may be n number of reasons. And what happens is that basis the contract, parties take position. Maybe people in the project may take position to safeguard themselves, or finance department of the company may be very strict in terms of imposing the liquidated damages without understanding that ultimately if you go in arbitration, you'll spend years. First of all, although the act intends that any arbitration should be completed in 1 year, we hardly see any arbitration getting completed in 1 year. It takes almost minimum average, in my view, is 2 to 3 years to complete an arbitration. And then there are challenges under 34, 37, and then up to Supreme Court. By the time, the relevance of the dispute is lost. But in mediation, we have seen, if I take the benchmark of Singapore, they have been able to resolve the dispute within 7 days, Tariq, on an average. But even if you take a longer time, and the best part about the mediation is that even if you have a dispute with a party, if you are able to resolve, you can still continue business. For example, let's take the example of a contractor to whom I give a EPC contract and there's a dispute. If the parties are able to resolve the dispute through mediation, I can say that if you resolve, I can give you future business. So it's a very, very win-win situation. And I think looking at the pendency in India, the legal cost, time, and the relevance of the decision, the business opportunity will be lost. And a lot of time, management time, and let's be practical today with the kind of disclosure which is required, especially for listed company in terms of contingent liability. It's better to settle the liability today rather than, taking it and carrying it in your books. So I'll stop here and, we can take it forward.
Thank you so much, sir, for a wonderful insight on this question. My next question is to Rajiv Malik, sir. So my question to you is that today we are in an era where consumer is the king of the market, and consumer pro legislations are all around us. Now, you're a stalwart of the FMCG industry. My question to you is that in this era, how the mediation and arbitration is an appropriate alternative dispute resolution mechanism than social media dispute resolution mechanism, because nowadays what we see is that every consumer tends to post on social media than to go for formal methods of dispute resolution. So what is your take on these alternative dispute resolution mechanisms than social media dispute resolution mechanism?
Yeah, thank you. Actually, it's a very interesting question and proposition also. These days, I am in the electronics industry, and most of the customers tend to escalate the things. So social media undeniably provides a platform where you can escalate your grievances, you can express your grievances, and of course, by gaining attention, you can gain attention. But it is important to know that it has its own limitations, right? It always is always end in a situation where the company becomes defensive, and the outcomes a situation is a win-lose situation. In other scenario where we are talking of the online and ADRs, there is a win-win situation, win-win outcomes are there. So that's here the difference comes. In fact, if you will see, especially in consumer cases and other things, ODR is becoming very popular in different countries. I do understand in India it's a nascent stage, but still many companies are using it very effectively. I have read somewhere that ICICI has resolved around 10,000 disputes through Sama, that platform. So there are other platforms also which are using the ODRs, and that I think that was the most effective, where we can have the trust building with the customers, with the company. And also, if you see the e-commerce websites, right, they also provide a straightforward chat box solutions to the customers, where it's just if the replacement or the refund is there, then it's very easy and simple mechanism. So I think instead of going to the social media, it is always better to have this ODR mechanism in place by the company, so that the trust that can be built with the both. Yeah.
Thank you so much, sir. Now, what I gather from this answer is that ODR is the way ahead in this tunnel of challenges. Thank you so much for a wonderful insight. My next question is to Madam Loomba. Ma'am, my question to you is that what are the common disputes in your particular industry that can be best resolved by mediation and arbitration? And we would also like to have a brief backdrop of your industry and your working culture.
Thank you for this question. Good afternoon, everyone. Well, the best disputes which can, or the common disputes which can be taken through mediation or ADRs are, I think, first you can start with the smaller disputes, something like consumer disputes. And this we tried in one of the companies that I had worked for previously around 15 years back, which was kind of proactive step. I was in a FMCG industry, Unilever, HUL. So in that company, we tried to evolve an ADR mechanism for consumer disputes. So we started a video conferencing kind of a dispute resolution. We appointed retired judges to resolve those issues. But it was a step way ahead of its times. Unfortunately, it did not have a huge success. But if we were to launch it today, I'm sure it will be very, very successful, because people are aware. They are wary of long litigation time. So they are aware of the benefits of ADRs. I think consumer disputes and smaller disputes, rather than going the litigation way, can be resolved. In addition to this, I think we should also learn from different jurisdictions, because now I'm managing different jurisdictions. Any dispute, before it goes into a litigation route in the West, there is inadvertently a settlement conference which takes place between the parties. So I think we should amend our procedures. Any dispute, commercial dispute, especially if before it goes to the courts, I think we should be having this in the procedure, that there is a settlement conference. At least the parties get a formal route to kind of come and discuss their dispute. So I think that will be really effective. We do have mediation clauses in our contracts, but as my co-panelist said, we don't know the effectiveness of that mediation panels. Usually any dispute, say if it is a channel partner dispute or a distributor dispute which it comes, I review it. I have a talk or a conversation with my business, and you sometimes as a general counsel, you have to step into the shoes of a judge and use your emotional intelligence, whether there are egos involved or is it a genuine dispute. And I usually try to push my sales team or my marketing team to go and kind of try to have a softer view around it, try to hear the party out and see if it can be resolved. A lot of disputes are nothing but ego clashes. So I think if we have a mediation, formal mediation set up within the company, you can send all these disputes there and hear out the parties. But the hearing has to take place by a neutral party. If we appoint any mediator from the company, I don't think the other party will have a trust or the confidence there. This is a vision with which I'm working. We still do not have that kind of a setup within the company, but I'm sure in times to come, we will think about it. I don't speak for the company, but in times to come, I think India is targeting to become a dispute resolution hub. So if we think of making India a dispute resolution hub, we will be moving in that direction and we will be creating that kind of an ecosystem.
Thank you so much, ma'am, for a wonderful insight. My question is to Tariq sir now. Tariq sir, as you've already elucidated the importance of institutional arbitration and mediation in the present times. But what we gather today is that mediation, from all of the panelists, is that mediation is not a very successful mode of dispute resolution in commercial disputes. So my question to you is that what are the common challenges which are being faced, and what is your input to overcome these challenges in respect to mediation especially?
So before I became the registrar, as a lawyer, I had the same view. What the panelists have said, that, that these are delaying tactics, referring matters to mediation in court. But now that I'm seeing mediation working, at least I can speak for our center. The success rate of the mediation matters, these are all high value disputes. Last week, we settled a matter of 350 crores, which was in court for 14 years. So I can speak for our center because we are very careful and I completely agree with Rajiv sir when he said that the issue is not with mediation. You do not have a pool of mediators who are trained. And training, I'm telling you, though I may have written books and I may call myself an expert in arbitration, but the training will change you as a person and the way you conduct mediation. It's a process, it's a science. Unless you do it, you would not know. I've done 4 trainings till now. Rajiv sir is now on the panel of Singapore International Mediation Center. So somebody as senior as him, who has seen these contracts all his life, who has seen litigation so closely, if he feels that training made an impact, made a difference, then I'm telling you, if you have the right mediator, the chances are very, very high that you will succeed. And mediation, I'll tell you why mediation is the only way. I recently authored a book on arbitration, what you mentioned. And I was very excited that, I'll reach out to Mr. Fali Nariman, because what I say may not have much value. Many of you are more experienced than me. Because in 2017, I heard him in a DISC conference that the future of arbitration is bright, and only because future of litigation is not. So I thought he's the best person to write a foreword. When I got the foreword finally from him, which is almost 16, 15 pages, he wrote just one paragraph about arbitration and everything else was about mediation. And I'll just read 3 lines what he said. He said, I support mediation, not because I'm skilled in it, but it is only because my experience of 7 odd decades both as a lawyer and as an arbitrator has convinced me that mediation should be the preferred mode of dispute resolution, not only to adversarial litigation, but also to the adversarial arbitration. So when the man himself feels somebody we look up to, the man we all want to be, so I'm sure there is something. So the problem is not with mediation at all. I'm still telling you, and those I'll be happy to personally connect to you and tell you more about mediation. I know today is not, we don't have the time, we're running against the clock. But if you do the training, I can assure you that it is in the best interest of your company. And anything that I can do to assist you, I'll be very happy to tell you more about it. But I urge you to undergo our training. Thank you.
I just want to add here,
Sure.
the mediation actually. Mediation is actually not a new concept in India. We know since Mahabharata time that Lord Krishna attempted to mediate between the two. And even after that, a lot of the Kulpatis and the Mahajans have actually tried to mediate in the thing. And actually conflict in any business is inevitable, right? But the problem is come with the litigation, which is actually self-destructive. And so combat is optional. So I think the mediation is one way where we can go further. I do fully agree with you. That is actually should be the way of life, that the mediation, I think so.
I think we are running short of time, but I will just like to add few words. I think what requires to change is the change in mindset. Taking your example, even if today you go to the mandis, where a lot of traders, they bring things and they do the trading. So there the dispute is settled. There are mediators, seniors of the mandis, who then and there settle the dispute. And the decision is taken and they honor and they move away. I think what is required is change in mindset. That yes, first, and mediation can be at any stage. You can do pre-litigation mediation. You can taste the arbitration and then do a mediation. So, and what I also learned is that mediation may fail at the first instance, but can again succeed at a subsequent stage. Because when you take positions and you're not willing to change your position, and then you travel and then you realize, no, this is better to settle and move ahead in life. So I think, India I see a very bright future as far as mediation is concerned. And as Tariq said, we need more trained mediators. And one more clarification, mediator need not be a lawyer. If he or she is not a lawyer, somebody can do a better mediation because there will be no prejudice and biases. So anybody can become a mediator, somebody who has an aptitude to be a good listener, to understand the position, maybe give a psychological, angle and aspects, and there are more than multiple rounds of discussion, and then, you see the success in terms of, deciding. So
Actually,
I'll stop here. We are running out of time. We can take
you
few
have
questions.
talked about the professional mediator. So I do agree that the mediator should be always trustworthy. There is always in fact, there is a conflict in between your heart and the mind also. Then who do you trust? So mediator should not get into the dispute himself. Yes, that's what I'm saying.
He has to be, like an umpire who is just watching, and then try and bring both the parties, facilitate him to arrive at a decision.
That's what I'm saying. Even if there's a dispute between our heart and mind, then whom do we trust? It's the supreme power, right? Whom do we trust? So we can surrender to them so that he can guide us, right? That's the way that, of course, the professional mediators can, of course, help.
Thank you so much to the panelists.